Good evening, everyone. Thank you so much for joining. I welcome you all to this session on understanding prevention of sexual harassment to build an empowered workplace. I'm Ruchira Banerjee. I'm a senior legal consultant at Locubata, and I will be conducting today's session. I would like to thank you so much for joining and taking out time from your busy schedule. The very fact that you are here to take ideas and discuss about empowering your team is a big win for them. So thank you so much. To set the context right for today's discussion, we will be talking about the law on prevention of sexual harassment at workplace, which I'm sure a lot of us are already acquainted with. We already know the law, but I'm guessing a little more information can help you. Apart from that, we will be also discussing the important provisions of the law, why this law came into its place, why was it passed, how was it passed, what are the challenges that are faced by organizations that at least we as a company, we have seen from our clients, what are the challenges they face. And definitely we will give you the best practices and solutions for those problems, right? Okay. Now, starting with the very basic, I would like to talk about the history of why this women-specific law, which we are talking about, the Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act 2013, which we commonly know as the POSH Act. Why was this law passed? I would like to open this option to all of you here. Does anyone know about the history? Does Bhanwari Devi ring a bell somewhere where you can help me that whether you know about the history of this law? You can unmute yourself or you can use the chat box.
Hi, Ruchira. This is Suma here.
Hi, Suma.
I understand that Banwari Devi, she was working in the village of Rajasthan. She was an helper there, basically a
Right.
pro-employee. She used to work for the women upliftment. So,
Right.
and apparently when she stopped the marriage of in village family, the child marriage,
Right.
she was gang raped and the husband was boycotted and she went through a lot of, the trauma. So due to
Yeah.
which she went and seek the NGO, and then the Vishaka guideline was laid down. So this bill became an act in the year 2013, so which is what now we have the POSH Act. Am I
Right.
right?
Yes, you are. Thank you so much, Suma. Thank you.
Yeah.
Thanks. Rajani, would you like to add something? You have message that you know about this case?
Yeah, so I am aware of this case.
Yeah.
There was one lady who was kind of harassed by the village people.
Yeah.
And then Vishakha, I mean, there was one female lawyer who kind of took the case and fought it in the Supreme Court and got justice for the lady. And after that, this POSH Act was established.
Right. Okay. Great. Thank you so much. Thank you. Well, I'll just add a few details there for our better understanding and for others who are not aware. So Bhanwari Devi was a Satin. So Satin usually means a friend, right? So they work as Anganwadi workers, and she was part of Rajasthan government's Women Development Program. Her job was to go door to door and to educate and spread awareness about ill effects of early pregnancy, ill effects of child marriages, menstrual hygiene, importance of having nutritious food, education for girl child. So her job was to create awareness around all these social topics. Now, it was in May 1992, and on the occasion of Akha Tej, which was considered an extremely auspicious occasion in Rajasthan, uh, Bhanwari Devi came across a family where uh, the family of Ramkaran Gujjar, they were getting their 9-month-old daughter married. Now, in this village, a number of other families were also getting their girl child married. So these social workers, they made a list of it and they sent it to the police. The police also tried to intervene and they wanted to stop the wedding, but it didn't happen. Right now, this of course Ramkaran Gujjar's family became very angry on the whole idea of all this awareness, and especially on Bhanwari Devi. And and Ramkaran Gujjar's family was a dominant caste there. They were quite influential. So they started a movement, boycott movement against the caste to which Bhanwari Devi belonged, which was into making pots and pottery. And they said that we will not buy any pottery items from this caste. They should learn a lesson and they should understand that, their limits. They should not come and teach us what is right, what is wrong. This happened, and in September 1992, Bhanwari Devi's husband was working in the field, and 5 men, including Ramkaran Gujjar, attacked Bhanwari Devi's husband. Bhanwari Devi tried to stop it because, there was no, she wanted to save her husband. So she tried to stop them. But unfortunately, 2 men pinned down the husband, and 3 men took turns to rape Bhanwari Devi. Bhanwari Devi wanted to report it to the police, but their fire was taken after a very long time, almost after 1 or 2 days. In the process, a lot of medical evidence was also lost. The police was not really happy with the fact that she's filing FIR. Nevertheless, when the matter reached the lower court dismissed this case, saying they stated a lot of grounds, some of which I'll share with you. One was where they stated that Bhanwari Devi is giving contradictory statement. There is no uniformity in statement what she's giving. The judgment also said that out of the 5 men, the 2 men were above 60. They cannot engage in such act of raping a woman. And it also said that 5 men belong to upper caste, and they will not touch a lower caste woman, which to the caste which Bhanwari Devi belonged to. Now, this was mockery of justice, and the entire country was outraged with this judgment. A number of women activists, lawyers, human rights activists, NGOs, they all filed a public interest litigation under the umbrella of Vishakha, where they requested the Supreme Court of India, saying that, see, Bhanwari Devi was doing her job. She was in her course of her employment. She had reached out to this family and tried to stop the child marriage, and she was just doing her job. The government, her employer, should have been aware of this, and I'm sure they mentioned that yes, they were probably aware of it, but they did not take any measures to provide any protection to Bhanwari, even before reaching out to the families and even after the unfortunate incident happened. She did not get any support. So the Supreme Court has to do something about it, where women, when they walk into a workplace, they feel safe, and the workplace is sexual harassment free. Now, this all happened in 92, 93. In 1997, the Supreme Court of India laid down what we know as the Vishakha guidelines. Now, these guidelines put a lot of responsibility on the employer to ensure a safe and sexual harassment-free workplace for women. It also stated that the employer must also provide for some process and some mechanism wherein complaints of sexual harassment can be handled. This particular guideline took the form of a legislation. It became a law in 2013, yeah, which is about 10 years ago from now. It is fairly a new law, right? And it is extremely strict when it comes to mandating certain things, which we will definitely discuss. It puts a lot of responsibility on the employer to ensure a safe sexual harassment-free workplace for women. Now, moving on, we will now discuss about who is protected. Given the history of this law and the very fact how this law was passed and why this law was passed more so, any woman of any age, whether employed or not, gets protection under this law. It means that any woman who is an intern or contract worker or a consultant, ad hoc, temporary worker, they are all protected under this law. Even women visitors do get protection under this law. Now, I'll give you one example here. I conduct a lot of trainings. Some of you may already know that. I conduct a lot of trainings on prevention of sexual harassment. I do it online, and I also go to the client's location and do a face-to-face training. When I, in my capacity of employment, when I entered into your work premise, the law provides this protection to a person like me also, who is a woman visitor in your workplace, right? So in that case, it's providing protection to all women of any age and need not be employed as in just like I stated, it could be an intern, a contract worker, or an ad hoc worker. Now, since we are talking about um, workplace sexual harassment, prevention of workplace sexual harassment, it becomes very important for us to understand what is a workplace. The law states that any place visited by employees during the course of employment, transportation provided by the employer, or any employer organized events, right, that is included within the definition of workplace, right? I mean, I would like to state in a way where I say to in my all my trainings, I mention this, that any place where your work is taking you is your workplace, right? A lot of people here, we all belong to different kinds of industry. Our nature of work is different. Some of us meet with clients a lot. Some of us interact only with our colleagues. Some of us have to meet the third party vendors. Our interaction is different, right, from day to day work. So any place where your work is taking you is your workplace. Nowadays, post COVID, we most of the employees, they are working from home. In that case, home is also a workplace. This particular platform that we are using to communicate today, or any platform that you use on a regular basis, be it Slack, Skype, any other platform that you are using to communicate with your employees on a daily basis, that is also your workplace. So any incident that happens within the ambit of a workplace will amount to workplace sexual harassment. Now, I would want every one of you to use the chat box option and tell me what, according to you, is an unacceptable behavior at the workplace. It need not be something that is sexual in nature. Any unacceptable behavior that you feel is unacceptable. What is it that, unacceptable behavior? Please let me know in the chat box. Unwelcome, unacceptable, something that you feel is not right. This is not the right kind of behavior. Bullying, okay, abusive language. I'm getting quite a few response here. Lack of respect, hugging without consent, okay. Anything that makes a man or a woman uncomfortable, uncomfortable staring, okay. Unwelcome stare, okay. I'm expecting some more response because we all have these boundaries, right? That this is right, this is wrong. Belittling or threatening behavior, cracking double meaning jokes, hostile work environment, okay, interesting. Uncomfortable gesture, any behavior without consent and respect, disrespectful tone while speaking, okay. Late night calls, all right. Anything else that you feel is unacceptable at a workplace? Showing inappropriate content on devices on phone, okay. Negative comments that might impact the workplace, all right. Comments on outfits, okay, that's interesting. Request for sexual favors, okay. Anything else? Body shaming, yes. Spreading malicious rumors or gossips, okay. Any more response? Blackmail, right? Alluring for promotion, demeaning or being biased to a particular segment in conversation, like assuming that a man will not participate in housework, right? Thank you. All right, I'll just give it 5 more seconds. All right, thank you so much. I think it was quite interesting to see that how all of us who are all different from each other and have some boundaries created around us when we walk into a workplace. What are the unacceptable behavior? Thank you so much for your response. I'm getting some more. Okay. Forcing being consistent on asking to hang out after work hours. All right. All right. Thank you. See, all these examples may become sexual harassment, may amount to sexual harassment, or may not amount to sexual harassment. It could be harassment in itself. Now, let's try to understand in this context what amounts to sexual harassment, right? Because we are talking about creating a safe and sexual harassment free workplace for everybody. So it becomes very important for us to understand what amounts to sexual harassment exactly. The law says any act or behavior which is unwelcome and sexual in nature, okay, will amount to sexual harassment. Now, this concept of unwelcome, like I mentioned, it is different from person to person, right? If say for example, I'm comfortable with a colleague whom I have that comfort zone, and that person walks up to me and probably we seeing after a long time, and that person kind of hugs me, I may be comfortable with that, right? But the same act maybe my colleague is doing with the other colleague, that person may not feel comfortable, and it might be unwelcome for that person, right? So what could be welcome for me could be unwelcome for another person, and that is absolutely fine. We are all different from each other, and the concept of unwelcome varies from person to person, right? Now, this law, which is defining sexual harassment, it says any act or behavior. Now, this act or behavior could be a physical advance or a contact. It could be brushing up against someone. It could be fondling someone. It could be holding of someone inappropriately, touching someone inappropriately. Even sometimes handshakes also become very uncomfortable, right? So I think there is a 3-second rule to a handshake, if I'm not wrong. Yeah. So then it becomes uncomfortable. Yeah. A demand or request for sexual favors. I'm sure all of us, we know that where there is a demand of sexual favors, say, you have to spend time with me, you have to spend the weekend with me, let's have some fun. You have to listen to me, you have to give in to my sexual favors, or else I will demote you, or I will not promote you. Or if you, kind of spend the weekend with me, then I can think of a promotion for you. These things will amount to a demand or a request for sexual favors. Making sexually colored remarks, it could also be some gestures as well. With respect to making sexually colored remarks, I would like to cite one incident which happened in a factory where in a factory, all these employees, they wear a overcoat on top of whatever clothes they are wearing, especially when they're on the floor shop. Now, they were allowed to open that coat whenever they are stepping out to have lunch, whenever they are going to use the washroom, going to the lobby. Now, one such day, this one woman employee, she walks out of the floor shop, she opens the coat, and she hears that a male colleague is singing a song about how women look pretty in flowers when they wear flower. And she herself was wearing a flowery printed dress that day. She understood that that song was for her, and she filed a complaint of sexual harassment. It was a valid complaint because this amounted to making sexually colored remarks, right? And the song was all about how women look lovely in flowers, how they smell fresh when they wear flowers, all of these things. Yeah. Sexual harassment could also be showing pornography, and it could be any other unwelcome or sexual in nature act which is physical, verbal, or non-verbal. Interestingly, I think in the year 2021, yes, it was in the year 2021, the High Court of Karnataka, they passed a judgment where they actually penalized, and since it was a criminal case, they actually had to send the man to a jail. He used abusive language against the woman, and he had showed his middle finger. So that was a non-verbal act of sexual nature, and it was unwelcome, and it did amount to sexual harassment. And the examples that I read out, and the when we were using the chat box, your response, some of it did amount to sexual harassment, like forcing someone to go out on dates repeatedly, um, body shaming someone, commenting on somebody's weight or looks, right? All of this, um, stalking, staring, we also call it as the elevator stares, right? Where you know that somebody is staring at you, yeah, and stalking, all of this amounts to workplace sexual harassment. Just remember one thing, that for any act or behavior to amount to sexual harassment, it has to be unwelcome and it has to be sexual in nature. These are the two important things that we have to keep in mind when we are looking into a complaint of sexual harassment. Now, I think some of the comments had come where we have spoken about speaking disrespectfully or labeling someone. Interestingly, the Supreme Court of India, just few days ago, they came up with a handbook on combating gender stereotype. Now, this is an effort the Supreme Court has taken where in their judgments and orders, they will use a much more gender fluid, equitable, and unbiased language. Yeah. So I have pulled up a little bit of portion from the handbook for our easy understanding. A lot of times, even in my experience, some of the witness while in a complaint, while handling a complaint, I remember one of the witness had come up and said, "Oh, that woman, the person who had filed a complaint, that woman is a woman of easy virtue. So don't believe what she's saying. She has filed a false complaint." Right? And it actually felt really sad, and I was really angry with the fact that we are labeling somebody, yeah, women we are labeling. And even I mean, I'm also very particular about not name shaming anybody or labeling anyone, right? And this particular handbook is a great initiative from the Supreme Court, and this is something that internal committee members or even employers for that matter can take into consideration when they are formulating their policies or when they are interacting with their employees, right? So it's quite an interesting handbook. You can definitely look up for it in the website, in the web. It's available. um, it's a good step in the sense that it also sets an example not just for judges when they are passing judgments, but also for us who are on a regular basis working in this domain of prevention of sexual harassment, when we are writing a report to the employer to talk about our recommendation and findings of the complaint, or when even we are interacting with the aggrieved person or the person against whom complaint has been filed, then in that case also something we have to take into mind where we do not use these labels as such, yeah, and we use a much more inclusive language. Okay, moving on. In my experience of handling complaints, which has been quite some time now and quite a few numbers, so to say, every time a complaint has been filed, the respondent is the person against whom the complaint is filed, has always reacted. The first reaction was, "Oh, but that was not my intention. My intention was not to sexually harass somebody," right? And our first response is that intention does not matter. What matters is the impact your act or the behavior has created on the aggrieved person, right? On the aggrieved, and what is the quantum of that impact? Yeah, that is more important rather than the intention. I'll give you one example here, wherein organization, they had stationed the security guard in the elevator. Now, the role of the security guard was to check the ID cards of all the employees entering the elevator, and of course, to help them to reach their respective workflows. One such day, the security guard walked up to a woman and turned the ID card because it was facing upside down. In the process, he happened to touch the woman's stomach, and that made her feel very uncomfortable because that was a very unwelcome touch for her. When a complaint was raised, the security guard, when he was informed and he came for his meeting, he said, "But I was doing my job. It was not my intention to touch ma'am inappropriately." But the internal committee had to make it very clear that, see, your intention was probably just to do the job, but your act of touching someone inappropriately has resulted into an incident of sexual harassment, right? So you need to be careful of how you are delivering your job. Even the law in this particular matter is also very, very strict, where it clearly states that intention does not matter, it is the impact that you create. Now, moving on, we will quickly discuss about how a complaint of workplace sexual harassment is redressed. Now, I want to ask you one question, and that is, where do you file a complaint of workplace sexual harassment?
POSH committee.
POSH committee, right? Okay. It is known as the internal committee, right? In organizations, we do, I'm getting some response here. Yes, internal committee, you're right. So a complaint of workplace sexual harassment must be filed with the internal committee within 3 months of incident. In case of series of incident, then the date from the last incident, 3 months from the date of the last incident, is when you file a complaint. Now, when a complaint is raised, and necessarily a written complaint has to be filed, in a lot of organizations, an email is also sent. That is also allowed. That is as good as a written complaint. When a complaint is filed, the internal committee sets up a meeting with the complainant, or I would say the aggrieved woman, first, to see, to get information about the complaint that she has filed. Now, the aggrieved woman has the right to choose either of the redressal method. What are these two redressal methods? One is conciliation and the other is inquiry. Conciliation is an informal resolution wherein the aggrieved woman puts in the terms of settlement. It could be, say, in form of written apology or oral apology or a warning to be given to the respondent. And the internal committee reaches out to the respondent to inform them that a complaint has been filed and the aggrieved woman has chosen conciliation, and these are the terms of settlement. If the respondent agrees, then in that case, it becomes a successful conciliation. The internal committee notes down all the dates of the events and all the details of what has happened on those dates, and prepares a conciliatory report, a conciliation report, and they forward it to the employer. In that conciliation report, sometimes, at least what I have seen, sometimes we also recommend the employer to provide for a warning letter. One very important thing to keep in mind, that in conciliation, an aggrieved woman cannot ask for monetary settlement, which means that the aggrieved woman cannot ask for money as a term of settlement. They cannot say that I want 20,000 rupees and I don't even need a written apology. Like, I don't even need an apology. Just the money will do if the respondent pays me 20,000 rupees. That is all is not allowed. No monetary settlement is allowed. Now, coming to inquiry, it may so happen that the aggrieved woman chose conciliation and the respondent refused to agree to the terms of the settlement, then it's a failed conciliation. It will automatically become an inquiry. Or it may so happen that the aggrieved woman asks the internal committee to conduct an in-depth inquiry. Now, the internal committee has a total of 90 days to conduct inquiry. Right? Now, inquiry, what happens is, after receiving the complaint and after receiving the request for conducting inquiry from the aggrieved woman, the internal committee has 7 working days time to reach out to the respondent and inform them that a complaint has been filed, and they can provide their side of the story within 10 working days. Their side of the story, as in what is it that they have to say, whether they have any evidence, whether they have any witness, all that details must be shared with the internal committee within 10 working days. After receiving the respondent's response, the internal committee will start its investigation. Now, while the inquiry is pending, the aggrieved woman can ask for what we call as the interim relief. Now, interim relief are certain reliefs that is provided to the aggrieved woman till the time the inquiry is pending. It could be in form of work from home or transfer of the respondent or transfer of the aggrieved woman to a different department, different floor, different unit or different branch, uh, different city, depending on whether they have the company has that capacity to provide that interim relief. Now, frankly, interim relief would definitely depend on the kind of the industry and the kind of the organization the aggrieved woman is working with, right? Whatever is feasible, accordingly, interim relief will be given. It could also be leaves, actually. It could also be leaves till the time the inquiry is pending. And all these leaves are paid leaves, right? In the process of inquiry, cross-examination also can take place, wherein the complainant, the aggrieved woman can write down certain questions for the respondent to answer. Same, vice versa, the respondent can also write down certain questions to seek answers from the aggrieved woman. But all of this will happen via internal committee, right? They will not engage in conversation with each other in a personal capacity and resolve this, but internal committee has to be present, and within 90 working days, this inquiry needs to be concluded. After inquiry is concluded, the internal committee must draft an inquiry report for which they have 10 working days and send it to the employer, which will include their findings and the recommendations. The employer has 60 working days time to implement the recommendations given by the internal committee. Now, if either of the parties to the complaint, that is the aggrieved woman or the respondent, they are unhappy with the recommendations given, because a copy of the recommendation is also provided to the parties to the complaint. If they are unhappy, they have the option to file an appeal with the court or the tribunal within 90 days from the date of the recommendations made. One very important thing here is either of the parties to the complaint, they are not allowed to bring in their lawyer or any legal practitioner to represent them when an inquiry into a sexual harassment complaint is going on. All right. I'm guessing you people, some of you may have some questions. Do save that up. We do have a question answer session. I'll definitely take up all your questions. Now, coming to false complaint and false evidence, we all know where there is a law, there is always a tendency to break it, right? So there may be situations where false complaint is filed, a malicious complaint is filed, or where a witness or any person who is called in to provide any information provides for a false evidence or false or forged documents, then in that case, disciplinary action can be taken against that person for filing false complaint or providing for false information or false evidence. Interestingly, in 2019, there was a incident that happened, and the court provided penalty against the aggrieved woman for filing a false complaint. So yeah, it can be penalized. Yeah, this act. But whatever the decision is, the internal committee must conduct a proper inquiry to it and only then provide for its recommendation whether it was a false complaint or whether any false information has been provided or not. Another very crucial thing about handling a complaint and when a complaint is raised, that is maintaining confidentiality. Breaching of confidentiality is prohibited under this law. What all cannot be breached? What all information cannot be let out? One, contents of the complaint. Second, identity of the aggrieved woman, respondent, and witness. In fact, any information which leads to identifying the parties to the complaint or the witness is prohibited. Any information relating to the conciliatory or inquiry proceedings. In one such matter that we had handled quite some time back, where we realized that one of the internal committee members, after holding meetings, used to let out information to the respondent and, giving assurance like, yeah, don't worry, everything is on your side. We know for a fact that, that this is a false complaint. and there was no sexual harassment, don't worry about it. We will definitely give a verdict which is, for you, which will benefit you. Of course, that internal committee member had to be pulled down from that particular complaint, and he was never allowed to be part of the internal committee anymore. But yeah, confidentiality cannot be breached. In fact, the law specifically mentions that an employer can penalize a person with an amount of rupees 5,000 if any person is found breaching confidentiality, right? And the service rules also are applicable. If service rules are there, then whatever disciplinary actions need to be taken can be taken as per the service rules. Okay, now coming to the mandates under the POSH law. Now, we have discussed about what is a workplace, what amounts to sexual harassment, and how a complaint of sexual harassment is handled, right? And we also know that it is the internal committee where we file a complaint. Okay. Now, here under the mandates under the POSH law, these are the things that are mandatory for an organization as a whole, and of course for the employer to be compliant to the POSH law. One is you need to have a POSH policy, which you need to formulate, disseminate, and publicly commit that you are zero tolerant towards sexual harassment. In fact, few days ago, the Supreme Court of India laid down certain guidelines where they mentioned that every organization having more than 10 employees must have an internal committee, they must have a POSH policy in place, and they must also in their official company website mention that they are compliant to the POSH Act, and this is the contacts of the internal committee members and the POSH policy. It must be made available on their official website. Some of the companies have mentioned they have mentioned that we are zero tolerant, and they have put up their POSH policy, right, on their official website. So you need to have a POSH policy in place. Second is the employer must constitute an internal committee by an order. Okay. Now, this internal committee consists of a presiding officer who is a senior level women employee. It consists of two more employees from the organization and one external member. Now, this external member could be a member who is aware of this law, who has been working, who is experienced and working in the domain of prevention of sexual harassment. It could be also an NGO representative, but it's ideally it should be someone who knows about the law. Right now, the composition of this internal committee must be 50% women, out of which, of course, the presiding officer has to be a senior level women employee. Now, the internal committee plays a very important role because they have to be sensitive enough to handle all kinds of confidential information, sensitive information. They must not be judgmental. They should be unbiased, and they should always follow principles of natural justice, which is giving both the parties to the complaint equal opportunity to tell their side of the story, to bring in their evidence, their witness. And in any case, if an internal committee member becomes a witness to a particular incident of sexual harassment, then in that case, they step down as internal committee for that particular complaint, and they become a witness to that particular incident. So constituting an internal committee by an order is extremely important. And like we discussed a few minutes ago about combating gender stereotypes. So they have to be open to learning. They have to be open to accepting certain things. They have to be inclusive, and the way they talk or how they handle a complaint, how they handle a crisis, all of these things, they must be capable of it. Of course, you have to provide trainings to them, but in general, they have to be quite sensitive about this whole idea of handling a complaint of workplace sexual harassment. The law also provides that the employer must display awareness posters at conspicuous places in and around the workplaces. Now, since most of us may be working from home, it is a good idea that you can probably send a awareness poster or awareness emailers to your employees to all your employees in case they are not walking into a physical workspace premises. Organize trainings and awareness sessions. That is something that you must do for all your employees, for managers, of course, for employers, for internal committee members. And if you belong to an academic institution, then definitely conduct trainings for all your staff, teaching staff, non-teaching staff, students, everybody. Right? That is something that is very important, that you must organize trainings and awareness sessions. The employer is also supposed to take action as per the recommendations of the internal committee that is made in the conciliation report or the inquiry report. And the internal committee, along with the employer of the organization, must submit an annual report at the end of the calendar year. Now, this annual report consists of 5 important pointers. One is the number of complaints received in the calendar year, the number of complaints disposed of in the calendar year, the number of complaints that are pending for more than 90 days, the number of awareness sessions and trainings conducted in the organization, and action taken by the employer. These are the 5 pointers that must go in your annual report, and you must submit it to your jurisdictional district officer. Now, if any of the organization is non-compliant, then in that case, the employer can be subjected to a penalty of rupees 50,000. In case they repeat this mistake, the penalty can double, and it may also lead to cancelling of your business license. Right? So whether an employer fails to constitute an internal committee or fails to act upon the recommendations or fails to even submit the annual report at the end of the calendar year, all of this will lead to non-compliance, and it may lead to penalizing of the organization. Now, in our experience of handling a number of clients from various industries, we realize there are 5 common problems that more or less all the industries, all the organizations and institutes they face. One is finding a reliable and experienced external member. Now, I work as an external member for a number of internal committees, and I know that experience really helps, right? Whether to handle a complaint, whether writing a watertight report, whether reviewing a policy, or even drafting a good POSH policy, experience of the external member counts. And that is extremely important to have one experienced external member part of your internal committee. Arranging for interactive and engaging awareness sessions, because we all know that the attention span of us, the humans, is very less. So it gets very difficult to draw their attention and actually to make them aware of their rights. So to arrange interactive and engaging awareness sessions is one challenge that the organizations face. Another is maintaining confidentiality of sensitive information. Um, I remember in one of the cases that we were handling, where the calendars, it said like, something like POSH complaint or a POSH meeting, right? Or the first meeting, POSH complaint, first meeting, all of these things were there. And the internal committee member was sharing her calendar with her team to kind of, to discuss some work. And in the process, a lot of people actually got to know that there is a POSH case that has come up, and, there's a meeting there. So, there was a lot of rumor around it. So that could have led to breach of confidentiality, right? So maintaining confidentiality is one of the challenges that organizations face. Apart from that, another challenge that they face is managing complaints efficiently within prescribed time frame, especially for inquiry where a 90 days time frame is given. And lastly, a very high cost which the organizations have to incur for implementing and setting up the procedures internally. Right? Now, these are the common challenges that we have seen across the industries that they face. And That's where we come. We try to solve these challenges and provide for the best practices. Now, for the best practices, we always recommend that always have a custom drafted POSH policy for your organization. What is applicable for organization A will not be applicable for organization B, right? Because the nature of work that you're doing, the kind of employees that you have, the industry that you belong to, it has its own demands. So have a custom drafted POSH policy, right? POSH policy, which is a best fit for your organization. That is something that you need to look into. Second is organize group discussions, theater-based awareness events, because these are more interactive. People are more interested to listen. Role plays, storytellings, these are extremely helpful. So try to organize for those. I mean, we also help our clients with these. So these are some of the best practices that I mentioned, right? Have a prominent, easy to understand, and multilingual awareness posters. And I will put a lot of emphasis on this because I have worked with a lot of industries. One be an educational institution, one could be a factory, one could be a hospitality sector, one is into tech, right? And there are different kinds of people, different languages that are spoken. So I may be comfortable in reading something which is in Bangla because I'm a Bengali, right? So if there is something in Bengali, I would show interest to read it, and it will create a much more impact when I'm getting, when I'm looking at that awareness posters, right? And there are different kinds of employees that you have in your organizations. So it is best that you have multilingual awareness posters. You never know it's going to help who, right? And these posters specifically talk about consequences of sexual harassment and what amounts to sexual harassment, what you should do at workplace, what you should not do at workplace. So these are all awareness posters, and it definitely helps all employees, even visitors who are walking into your workplace. Another solution that we have is awareness sessions that you conduct. It can be face to face and it could be also online. All right. The main key is that you create awareness. It could be through e-learning sessions, it could be through webinars like these, or it could be offline, face to face. Yeah. Conduct quiz and provide certification. Quiz and assessments are mainly to understand whether the person who has undergone a particular course, or whether they have when they participate in a webinar, whether they have understood. So assessments are ways of understanding whether the main idea, the main knowledge has been imparted to the employee or not, whether their understanding is perfect or not. So that is something that you can look into by conducting quiz and provide certification for that. If you're providing for e-learning courses, then definitely provide a certification for that. Conduct surveys. This is extremely important, more so because, I mean, see, you conduct a training once or twice in a year, that is all right. But the internal committee, the employers, they must be approachable. They should also know the fact that what is happening in their workplace, right? So conduct surveys at various levels, whether, they have any feedback to give, whether they have any suggestions, whether they have any ideas on creating much more awareness in the workplace. So that is something that, you can look into. Now, all these solutions is provided by Locubator. I would like to think, and rather it is the case so, that Locubator is a one-stop solution for all these problems, all these concerns related to prevention of sexual harassment, and not just that, any other work-related compliance. So Locubator is a platform which takes care seamlessly, like a seamless management of any HR or legal regulatory compliance that you need to take care of in your organization, right? Prevention of sexual harassment is one of the compliance that we are discussing today, and definitely there are solutions for that. But yes, Locubator has a lot more to provide. It has a lot of e-learning courses on various compliances, right? Which will help you your organization, your employees to be much more aware of what is right and what is wrong. And I think that is the most empowering thing. Now, what we'll do is we'll quickly watch a video right now to give you an understanding about what Lockubator has to offer. And after this, I'll take up any questions that you may have, right? Right. So, like I mentioned, Lockubator will provide you with all the solutions for all your concerns and all your problems that you may be facing with any compliance at your workplace. Now, I would want to open this to the floor and to everyone here. If you have any questions, please go ahead one by one, and I would be happy to help you out with your concerns.
Ruchira Sumad this side.
Yeah.
I have a question. See, you
Yeah.
were explaining me about the timelines, right?
Yeah.
There's a one timeline you explain about the 10 days where the employer, once we finish the redressal process and we write it to the employer for the recommendation.
Yeah.
Is that the 10 days?
So there are two 10 days here. One is, one is after receiving the complaint where the aggrieved woman has asked the internal committee to conduct inquiry. The internal committee reaches out to the respondent within 7 days time. And the respondent has 10 working days time to come back with their reply. Okay. Whether they have any evidence or witness or their side of the story. Okay.
Done.
The next 10 days that I mentioned about is the 10 days after inquiry has been conducted. This 10 days can be utilized by the internal committee to prepare their inquiry report, the report of findings and recommendations.
Okay. For example, sorry to disturb you. For example, today I have completed one conciliation process. Today when both all parties sign the conciliation, it stands closed. So from today, I have 10 days to prepare my all the the report and submit it to the employee. Is that you mean to say that?
No. So these timelines that we mentioned about is applicable only when it is an inquiry. For conciliation, the law does not specifically mention any dates. All right. As a best practice, we internal committee members try to close a conciliation complaint within 15 working days. Okay. So the timelines that I mentioned about 7 working days to reach out to the respondent comes back in 10 working days, 90 days of looking into the complaint, and then 10 working days of drafting the inquiry report. All that is for inquiry.
Inquiry procedure. Understood.
Yes.
Okay. Yeah. Thanks. Yeah.
I'm glad I could help. Thank you. Any other questions? Any question is fine. No question is a bad question. Don't worry.
Ruchira,
hi.
So sorry. Yeah.
Sorry. No, sorry, go ahead.
No, please go ahead. No problem.
Okay. So, Ruchira, this one question I've been asking on every call with every POSH training that we have.
Okay.
Is, does the law still envelope men at workplace also in this policy? Is it gender neutral? Is there some sort of a fairness that allows men also, to safeguard men? Because I see a lot of, I can't say that without being judged, but it's kind of made them more vulnerable rather than safe. Now they are unsafe and we are like pretty much very safe, airtight, safe.
I'm glad you asked that. So, See, the law, like I mentioned, because of its history, it clearly provides protection to women against workplace sexual harassment. But the law nowhere it says that a woman, a grieved woman, cannot file a complaint against another woman, which means the respondent could be of any gender, right? But yes, like you mentioned, we have this notion where we always think that, okay, if a woman is getting sexually harassed, which means the harasser is a man, right? Which is actually a wrong notion, but it's a very common thing. It's a first thing that comes to our mind. Now, coming to at organization level, you can definitely have a gender neutral policy, right? You can stick to whatever the law is saying, but you can also have a gender neutral policy where you can include and extend this protection against workplace sexual harassment to all the genders, to all the employees who walk into your workplace. So yeah, to sum it up, you can have a gender neutral policy, but you have to define certain things as to how you're going to file, how you're going to handle this complaint, what are the interim reliefs that you can provide when a complaint is filed by a man, yeah, and not an aggrieved woman. Yeah. Thank you.
Thank you.
Yeah, Ruchira, adding
Yes.
to the same question,
Huh.
see, when we follow this gender neutral policy, right, if the respondent is not happy with the recommendation, right, so he cannot go for an appeal because the law does not
Yes.
give any that, right? Then in that case, how do we go about it?
Yeah. See, there are certain problems. Problems as in these statutory provisions of going for an appeal when the aggrieved person is a man, when it's a aggrieved man, then in that case, the law does not provide for any protection, right? It does not provide for any step as such. So in that case, that could be a challenge for sure. But what you can do is you can have an appellate authority set up in your organization where people from the higher employment level, they can look into the matter and provide for some solution to that. So you can have an appellate authority within the organization. So like I said,
Through a
in your
COC process.
sorry,
Through a COC, we can have a code of conduct.
right. So you can set up an internal appellate authority, especially for people like aggrieved man or anybody who's from a third gender. Yeah.
Okay. So you're telling that, see, now we follow gender neutral policy at our organization.
Yeah.
So any male member comes with a complaint, so he's equally protected under this policy, right?
Right.
You mean to say that the procedure or the redressal is the same like how it's supposed if it were to be a woman, and the recommendation what has been passed will be taken through the COC. Is that right?
See, it would depend on the structure of your organization, Suma, right? Whatever works for your organization, that is something that you have to figure out. I mean, see, the law is there, and we take clue from the law that, okay, this is how we are going to handle the complaint, no matter whoever comes, right? But then there are these problems, like you mentioned, where an aggrieved man cannot file an appeal to the tribunal or the court, right? Because that provision is not given under the sexual harassment law. So in that case, I would suggest the best option would be to have an appellate authority within your organization. Yeah, just in case an appeal comes up from an aggrieved man or a aggrieved third gender person.
Sure. All right.
Yeah.
Yeah, thanks.
Okay. Any other questions, please?
Ruchira, I'm Sushant here.
Yes.
Just wanted to understand the severity of the offense. Its final judgment. We already know that there are no monetary fines or anything as such. So, what will be the final judgment? Are there any cases if you can tell us about how the final judgment will be given if the other party is chosen guilty?
See, this internal committee provides for disciplinary action to be taken, right, against a person, against a respondent, if it is proved that the sexual harassment incident did take place, or where the aggrieved woman has filed a false complaint, right? So a disciplinary action can be taken, and to what I have seen, the most severe form of action that can be taken is terminating the employee from the organization, right? The law also provides for compensation to be paid, but it depends from case to case and whether it is required for any compensation that needs to be paid either to the aggrieved woman or to the respondent. But all these are in form of disciplinary action. And in a case where the internal committee is handling it, then definitely I think termination is the severe form of disciplinary action that the internal committee can recommend.
Thank you.
I can take some more questions and help you out. Please let me know. All right. Thank you so much. Thank you everyone for joining. Please reach out to us at support@lawcubator.com if you have any questions, if you have any doubts, if you need any help from our end, we'll be happy to help you out. Thank you everyone. Thank you for joining. Have a lovely evening ahead.
Thanks, Ruchira. Thank you so much.
Thank you.
Thank you, Ruchira.
Thank you so much. Thank you for joining.